Here we go. Turn that off. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2 of Jefferson County, Texas. My name is Judge Terrence Holmes. I'm the presiding judge here this morning. This morning, you have been asked to come here for the arraignment or for your arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in County Court at Law number 2 is a misdemeanor case. We handle Class A and Class B misdemeanors. Now, criminal cases are divided into either a felony case or a misdemeanor case. Your felony cases are normally referred to as your most serious type cases. These are cases where you have capital murders, aggravated sexual assaults, aggravated assaults, aggravated robberies, burglaries of habitations, burglaries of vehicles. I mean, not vehicles, but burglaries of buildings. You also have some serious type drug cases and other cases that we classify as felonies. Now, your misdemeanor cases are normally referred to as your petty offenses. It does not mean that they're not serious. It just means that the punishment that you get for a misdemeanor is is much less than the punishment that you will receive for a felony case. And so your misdemeanor cases are cases like criminal trespassing, driving while intoxicated, possession of a marijuana, normally less than 2 ounces. You have possession of a controlled substance, normally pills, or it could be a possession of a controlled substance, penalty group 2A, which is commonly referred to as synthetic marijuana. You have evading arrest, evading detention, resisting arrest. You have assaults. You have what we call like just regular assaults. So you might have family assaults. You have criminal mischief cases, burglaries of vehicles, theft cases. Not all theft cases, but normally theft cases are below a certain amount. And so your misdemeanor cases, as I said earlier, or as opposed to your felony cases, the difference is the range of punishment. For example, I mentioned that a capital murder case is a felony. Capital murder, you get life or death as your punishment if you're found guilty. For a first-degree felony, like a murder case, your punishment can be 5 to 99 years to life in a state penitentiary, and you could get a fine up to $10,000. For a second-degree felony, the range of punishment minimum of 2 years, maximum of 20 years in the state penitentiary, fine up to $10,000. For a third-degree felony, range of punishment is 2 years to a maximum of 10 years, fine up to $10,000. And the lowest felony we have is what is called a state jail felony. State jail felony, range of punishment is minimum 6 months to a maximum of 2 years in the state jail. Now, for your misdemeanor cases, they are divided into Class A, which is the highest, B, and C, which is the lowest. Class C misdemeanors, normally we get those cases when we get them on appeal. If they're appealed up from the JP court, that's the justice court, or the city court, which is the municipal court. Those cases, just to give you an idea of what the Class C misdemeanor is, a speeding ticket, a speeding case is a Class C misdemeanor. And the difference between the Class C misdemeanors and the A and B is that with the Class C, is fine only. You cannot get any jail time. Now, for the Class A misdemeanor, which is the highest misdemeanor that we have in Texas, the range of punishment is confinement in the county jail for a term of 0 days up to a year or anywhere in between, a fine from $0 to $4,000 or anywhere in between, or you could be given both such fine and confinement. For a Class B misdemeanor, the range of punishment is confinement in the county jail from 0 days to 180 days, which is 6 months. A fine from $0 to $2,000, or anywhere in between. Or you could get both such fine and confinement. Now, you may qualify for what we call probation. There are two types of probation. One type of probation is called unadjudicated probation. We normally refer to it as deferred probation. And the other type is called adjudicated probation, and we refer to it as regular probation. And the difference between the two are as follows. With the unadjudicated probation or the regular probation, it does not result in a conviction in your record. And if you successfully complete it, the case will be dismissed, and you may qualify for what is called a non-disclosure. Non-disclosure basically means we cannot tell the general public that you were on deferred probation or unadjudicated probation for your offense. However, if you violate the terms and condition of your probation, your unadjudicated probation, the state can file a motion to revoke your probation. You could be arrested. You'll have an opportunity to have a hearing. You have a right to have a hearing in court. And your hearing will be before the judge only, it will not be before a jury. And if the judge finds that you have violated your probation can be revoked. Revoked means you could be kicked off of probation and you may get a conviction. If you get a conviction, obviously, your case is not going to be dismissed and you cannot get a non-disclosure. Now, for regular probation does result in a conviction in your record. However, there is something in the law that is called judicial clemency. And with judicial clemency, that gives the judge the authority to set aside your conviction. In essence, you will no longer have a conviction. And the way it works, first of all, you have to successfully complete the regular probation. You cannot have any more time left on the regular probation. And then the court has to discharge you, which means to let you off of the regular probation. And if those things happen, then the court can allow you to come back in the court to withdraw or to take back your plea. And if the court allow you to do that, and if you do that, then any complaint, affidavit, information that has been filed against you will be dismissed, and your conviction will be set aside, and that's when you will no longer have a conviction. However, if you get a subsequent or a conviction later on for another offense, then this case can be brought back up, and it could be used against you. If you try to get a license with CPS, they can revoke, suspend, or deny giving you a license with CPS. All right. Now, the paperwork that you have in your hand that was just handed out to you earlier, I'll go over that paperwork with you. It says, judge's explanation of rights to defendants without attorney. As a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number three, you may represent yourself. If you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset to give you time to do so. Reset means it'll be set off on another date. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of the document, it states, defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you'll put your initials on the first line to the left. If you've already hired an attorney, then you'll put your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you'll put your initials on the third line to the left. If you've already been appointed a court-appointed attorney, then you'll put your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney and represent yourself, then you'll put your initials on the line, the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign at the bottom of the document where it says defendant, and you will date it today's date, August 24th of 2021. Now, for those individuals who will be representing themselves, you'll have an opportunity to talk to the prosecutor to see if you can work out something on your case today. However, you have to sign a waiver of counsel, and that waiver is the second page. And on the second page, it reads waiver of counsel for purposes of entering a guilty plea or proceeding the trial. I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 24th day of August of 2021 by the county court at law of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that's your choice, then you will sign where it says defendant, and you'll place today's date where it says date, August 24th of 2021. Now, ladies and gentlemen, you also have other rights. For example, you have a right to have a trial by jury. And what a gentleman is sitting in the that area over there, we call it the jury box. 6 citizens from Jefferson County will be selected to sit on your jury, and they will decide whether or not you are guilty or innocent after listening to all of the evidence. You also have a right to waive your right to have a trial by jury, which means you have a right to give up your right to have a trial by jury. And if you do so, your case will come before the judge. It will come before the judge if you want a trial. We call that a bench trial with a judge only. If you are entering a plea of either guilty or no contest to your case, then it will come before the judge on a plea if you have a plea bargain agreement with the state, or if you do not have a plea bargain agreement with the state, then you will be coming before the judge on what is called an unagreed plea, whereby you are asking the judge to set the punishment in your case. You also have a right to have witnesses to come to court to testify. Witnesses, they sit in that area right there in that chair. We call that the witness stand. They can testify for you or against you. You could ask them questions. We call that either direct examination or cross-examination. You also have a right to waive your right to have witnesses or to give up your right to have witnesses. And if you waive your right to have witnesses, you will not be calling any witnesses in your case. However, the state will be calling witnesses in that case. Now, you also have a right of what we call a right against self-incrimination. It's normally referred to as your Fifth Amendment right against self-incrimination. That simply means that you have a right not to testify in your case if you desire to do so. The state cannot force you to testify if you do not want to testify. Now, you also have a right to waive your right against self-incrimination or give up your right against self-incrimination and testify if you desire to do so. You also have a right to see the evidence. We call that you have a right to have discovery, to see the evidence that the state has against you. You have a right to have access to that evidence. If you're representing yourself, now, if you're represented by an attorney, your attorney will be given copies of the evidence that they're entitled to get by law. Now, you also have a right to waive that right to see the evidence or have the evidence in your case. And by doing so, you'll be giving up or waiving the right to have access to that evidence. Now, in your case, you can enter one of three types of pleas. I know you heard me referring to plea of guilty, plea of no contest. I'll explain that to you. If you enter a plea of guilty, you're telling the court that you committed the offense that you have been charged with. If you enter a plea of no contest, then you're telling the court that you will not be fighting or you will not be contesting the charges. Or if you enter a plea of not guilty, you're telling the court that you did not commit the offense that you have been charged with. Every one of you have been arrested on your case, and you are out of jail on bond. Every day that you spent in jail could be used as credit towards your punishment, and I'll explain that to you. For example, if the state is off, let's say you spent 5 days in jail before you bonded out, and the state is offering through a plea bargain agreement that your punishment will be 5 days in jail. Well, if you spent 5 days in jail, the time that you spent in jail can be used as credit toward your punishment. That just simply means that you will not have to serve any more time in jail, because you will be, that means that you won't have to serve any more time in jail. You'll be given credit for the time that you have already served. We call that credit for time served. Now, if they're offering you 6 days, you spend 5, that means you have to do 1 day. Now, every day that you spent in jail also can go towards your fine and court costs. So every day that you spend in jail is $100 towards your fine. So you spend 5 days in jail, it's $500. State is offering you a fine and court costs of $500. You won't have to pay anything. Why? Because you spent 5 days in jail, and your time in jail has already paid it off. Therefore, your time will be taxed and retired. Now, if you had spent, if they're offering the fine and court costs of $600, that simply means that you would have to pay $100. But let's say you can't pay the fine. They offer you a fine and court costs, but you can't pay the fine on that day. Then, well, we can put you on what is called a payment plan, which means that you can pay it in monthly installments, small portions until you paid it up. But let's say you can't pay it at all because of your financial situation. Then we can convert the fine and court costs to community service. And what that means is you won't have to pay it out of your pocket because you don't have the money, but you can work and doing community service, and that will pay it off. So every hour that you're doing community service, $12.50 will go towards your fine and court costs. So if you work an 8-hour day, that's $100. $100 will go toward your fine and court costs. So now Jefferson County District Attorney's Office has a program that is called pretrial diversion. Pretrial diversion is a program for first-time offenders. And basically what happens in that program, you get in the program, your case is dismissed, you can get it expunged from your record. Expunged means it could be erased, deleted, or wiped off from your criminal record. Now, the way it works, you would, it has to be your first, you have to be your first offense. It cannot be an offense involving resisting arrest or unlawfully carrying a weapon. And you have to have an attorney to assist you to get into the program. And if you are a veteran of any one of the branches of the United States military, the DA's office has a program that is also called Veterans Court, and it's for veterans only. And it's part of the pretrial diversion program. So you just basically have to be a veteran. You get into the program, you qualify, get into the program, your case is dismissed, or you complete the program, the case is dismissed. It can be expunged, erased, deleted, or wiped off from your record. And if you're interested in any one of those programs, just let us know, and we'll be able to direct you to the people that you need to talk to in order to get into or qualify for one of those programs. Now, the other thing, he has a case here. The other thing, ladies and gentlemen, we have a program that is called the Community Safety Initiative. Community Safety Initiative basically means, it stands for the CSI program. With that program is designed to make Jefferson County a safer place by addressing the issue of what we call recidivism. Recidivism is where people commit crimes over and over. And the way we address those programs is basically we have a partnership with some agencies in our community. We have, if individuals who may have mental health issues, we have a partnership with Spindletop. Spindletop Center is a local mental health facility. They can address the mental health needs of individuals by doing a private interview, doing assessment, and developing a treatment plan, either outpatient or inpatient. Also, Spindletop has a program that is called ATAR. ATAR stands for Addiction, Treatment, and Recovery. And it's a recovery program for individuals who are addicted or addicted to drugs and alcohol. And they can come in and do a screening, develop a treatment plan, and you could be, they could place you in either outpatient or inpatient treatment to address your drug or alcohol addiction needs. We also have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. With that program, it is a job training and a job placement program. Individuals are trained in the hotel industry, the chemical industry, and the shipping industry. Once they are trained in one of those areas, they will assist them at getting a job in the area that they are trained in. Now, if you have not finished high school, you do not have a high school diploma, the CSI program also has what is called a GED program. The GED program is assists you to get your high school diploma. Now, all of these programs that I've just mentioned are free. It does not cost you anything to get into the programs. Only thing you have to do is have a desire to be in the program. And these programs that I've just mentioned is programs that I started in the CSI program when I started it back in March of 2017. And hundreds of people have been helped and benefited from the program. I say this all the time: when you come to County Court Law Number 2, we just don't have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference of the lives that comes before the court. And we're trying to make a difference in the community in which we live, Jefferson County. In County Court at Law Number 2, we do not just arrest the problem, we address the problem. And we believe by addressing the problems, we can make the individuals productive. And by producing productive people, for the most part, productive people do not commit crimes, and therefore we can address the issue of recidivism to reduce the crime in our community. Also, we have some individuals, that represents Spindletop, and we have individuals that also represents the Veterans Administration. We have Jess, who is with Spindletop, and Jess is going to come before you and talk to you about the program that we have here in Jefferson County with Spindle Top. Jess?
Well, my name is Jess. I'm a qualified mental health professional. Or I can actually link you with the other person who's not here today. His name's Wade, as well. So, does anyone have any questions for me?
Okay, thank you, Jess. Okay, ladies and gentlemen, what we're going to do is the paperwork that was passed out earlier. We have someone from our court that's going to go over that paperwork with you. Also, Jess will probably come around and talk to you as well. And so it's going to take a few minutes. So just bear with us now. If you need to go to the restroom, you have time to go to the restroom, but do not leave the courthouse, because if you leave the courthouse without being released by the court, your bond is going to be forfeited, a warrant is going to be issued for your arrest. So just bear with us for a few minutes. It's going to take some time for us to go through and sort through those applications and forms that you have filled out. So at this time, ladies and gentlemen, we'll be in recess.